the hell do you jump to that conclusion? You lied to me.
Context.
You want me to play it back?
Judge, I certainly do not. But
you want me to play it back?
Judge, I certainly, if Your Honor some other time wants to, that's fine.
No, you want me to play it back. You're playing fast and loose with words. You need to file a written motion. How long is that going to take you?
Judge,
how long is that going to take you?
Judge, certainly.
How long is that going to take you? You're wasting my time.
This defense attorney walked into Judge Simpson's courtroom acting like he was about to rewrite the law. He's trying to argue that the judge shouldn't even be on this case because he was the one who signed the original search warrant that led to the evidence. That's completely legal and every real attorney knows it. His whole argument just feels desperate, like it's just trying to stall or confuse a court. You can even see the judge's patience slowly running out as he lets this guy talk himself into a corner. Oh yeah, and he just straight up lied to the judge's face. Let me know in the comments if you think this logo might be on something that rhymes with propane. If you know what I mean, let me know. But let's dive in here and watch. Music.
Stand and give your full and complete name for the record.
Thank you.
Judge, if I may, very briefly.
Go on.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context, for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's dark brown skin with barrel rolls. Judge, notwithstanding saying, Your Honor, the sole basis that the people intend to introduce quote-unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge.
I don't know what case you're talking about. Who's the co-defendant?
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that the defense counsel is attempting to
well, then I'll let him finish, because I don't know, it did not even begin to ring a bell with me.
It shouldn't.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with two search warrants in this particular case. Ultimately, these two search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People Be Real, which is 391-124, Judge, it certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case, and specifically the case law says.
Whoa. How the hell do you jump to that conclusion? Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue because I think it's a... Go ahead.
Thank you, Judge. And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says if the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter. Certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your position,
does that case clearly apply to search warrants?
That it's not limited to search warrants.
But that isn't what I asked you, Mr. Martel.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to.
Judge, what I'm
just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they've made a finding.
Judge, specifically, this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moot. But
I have read, so that we're clear, because you're playing fast and loose with words. So that it's clear, I would have read the search warrant. I don't recall receiving any testimony at all regarding that search warrant, because I typically don't. I make a determination if there's probable cause contained within the four corners of that document, swear the individual in, sign off on the search warrant. It's really as simple as that. So if you show me a case, Mr. Martel, that says under those circumstances the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time.
So now this attorney is really trying to claim that Judge Simpson is biased just because he signed the search warrant earlier in the case. He's saying since the judge already found probable cause once, he can't be neutral now. But the judge shuts that down immediately, pretty much just saying he didn't hear witnesses or make any rulings. He just read the affidavit and approved it. That is just how warrants work. It is literally a part of the process. I mean, this defense attorney really looks like he's trying to sound smart, but end up sounding like a first-year law student bluffing through a final exam. It really is just painful to watch because it's doing his client no favors here. And just the longer he keeps going, the more you can tell Judge Simpson is ready to move this along. And that is a nice way to put it. If you guys think this attorney is delusional, leave a like on this video. I'm curious to see how many people are level-headed like me.
Judge, so acknowledged, I would say that Burrell is applicable, and I would also humbly submit, Judge, to the position of the court that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion. So I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
how long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just do that?
We're prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. And please, this most honorable court, Edward Martel, P85051, on behalf of Darren Dwayne. State your name once again for the record.
Have a seat. So, Mr. Martel, you know, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but if the case that you're referring to as a co-defendant is Christopher Harrison, I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding refusal started with and I hate using the word, but it's true. It started with a lie. Then, Mr. Martel, you continued with your lie regarding the import of the case of People versus Burrell. You cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
If I may.
If it's not going to be a lie, go for it.
Judge, respectfully.
No, you lied to me.
Okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not. But
You want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're going to sit up here and tell me you didn't lie to me, you want me to play it back?
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentations of the context. The main argument is what it is. And certainly Your Honor is not barred from presiding over this exam. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is, because everything that is presented to me is not it.
This guy just keeps doubling down, and it is getting worse by the minute. He's literally just nitpicking legal terms that don't even apply to this situation. And it's just so obvious he's just trying to get this case reassigned to another courtroom. Like, I don't know if he has beef with Judge Simpson or what, but it just feels like there's some kind of animosity towards Judge Simpson here. Like the moment he walked into the courtroom, his hands were swinging around like pointing at the judge with this cocky demeanor. And like every single minute since he walked in, like the tension has just been building. And like on a real note, I really just feel so bad for this defendant. Imagine just sitting there watching your own lawyer tank your case in real time. And the thing is, Judge Simpson could easily hold this guy in contempt for the way he's spinning things, especially since he literally lied to him. I mean, I have seen plenty of lawyers push boundaries, but this guy is just playing with fire. I mean, he literally just made that stuff up. If you guys think this attorney is sketchy and probably just making things worse for his client, let me know if you guys agree in the comments below. But we're not done yet. Let's dive back in.
Anything else, Mr.
Judge, just very
Martel?
briefly, and I certainly respect this.
Because I'm going to tell you that, quite frankly, Mr. Martel, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recused for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor. And I certainly had no intent to mislead this court. Or in fact, I'm going to pull the exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth. If it's the position of the court that it's not, certainly, Your Honor, we will move forward with your denial, and we're prepared for it.
I have not ruled. You will hear my ruling loud and clear.
Yes,
But do
Judge.
not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26th, 2024 at 12 noon.
Thank you, Judge.
This hearing was something else. Usually, We're watching defendants talk themselves into trouble, but today the defense attorney stole the show for all the wrong reasons. This dude literally could have just kept things simple and focused on the evidence. But instead, he decided to test the judge's patience, and that is just never a smart move, especially in Judge Simpson's courtroom. I really wouldn't be too surprised if this guy gets a few choice words from his client after this. It's wild how often lawyers end up being the reason their clients lose ground in court. But yeah, like I said in the beginning, something that rhymes with propane the attorney was on. I don't want to make too many bold accusations of this guy, but it really did seem like he was on something. Let me know in the comments if you guys agree. But as always, guys, I really appreciate you guys watching. Make sure to like and subscribe. If there's enough love on this video, I will be making a follow-up. So thanks again, guys, and take.